can begin.
Sure. Hello, my name is Pia Thompson. I'm a bankruptcy partner at Gould & Ratner in Chicago, Illinois. I'm here today to speak with you about an introduction to Chapter 11 reorganizations. Bankruptcy is an ever-evolving practice. Years ago, it was viewed as shameful and a refuge of last resort for a lot of companies. In the last 10 years, it was used aggressively as a business planning tool, and now bankruptcy is once again in flux. One would think that given the dire financial straits faced by many companies across the United States over the last couple of years, that bankruptcies would be through the roof, but they're not, as we sit here in the fourth quarter of 2010. But that, I'm afraid, is a topic for a different CLE. I'm here today to provide an introduction to Chapter 11. And basically, I describe this as a set of tools to let you know what you don't know. The United States Bankruptcy Code is often viewed as a foreign language to those of you outside the industry. So this, along with the materials you're receiving with access to this video, there's the first thing I'm going to go through is a glossary of terms, sort of our terms of art, so you'll have an understanding of what everyone's talking about. And we'll start with the beginning. Commencement of a bankruptcy proceeding. A bankruptcy case is commenced with the filing of a bankruptcy petition with the bankruptcy court, and a debtor may commence proceedings by filing a voluntary petition. In certain instances, creditors initiate the proceedings by filing an involuntary petition, and the filing date is often called the petition date, and that becomes an operative date by which things are measured during the case, and you'll see that highlighted in my talk. There are four principal players in a bankruptcy case, the first and foremost being the debtor. The debtor is a person or business that's the subject of the proceedings, where the debtor remains in control of their property. They are referred to as a debtor in possession, and we also just use the phrase DIP. One thing to remember is that the Bankruptcy Code often refers to powers of a trustee. In the circumstance where you have a Chapter 11 case with a DIP, the code won't say trustee or DIP, but that is implied. If you have a DIP, they step into the shoes of the trustee and would have all the powers enumerated in whatever section you happen to be reading. So that's something to remember. Often lay people, and when I use that phrase, I mean people who don't practice in bankruptcy regularly, when they read sections of the code that refer to powers of the trustee, they think that perhaps those are not powers for a debtor in possession, so I want to make sure there's no confusion on that front. The second player is the bankruptcy trustee. A bankruptcy trustee may be appointed or elected to take control of the debtor's property, but as I just explained, as a general rule, there is no trustee in a Chapter 11 case. The DIP remains in possession of the assets and the operations of the business. To contrast with Chapter 7, just so that you understand sort of the other arena, Chapter 7 is the liquidation chapter, and there is always a trustee appointed to take over the assets and the operating of the business in that circumstance. And frankly, they're not really operating the business for long, as Chapter 7 is the liquidation chapter. So a trustee is appointed to liquidate the assets and shut the business down or find a buyer. The next group are the secured creditors, and those are creditors who possess liens on the debtor's property. Secured creditors can be either fully or partially secured, depending on the value of their collateral. And the last group is the unsecured creditors. Unsecured creditors don't have liens on the debtor's property, and thus generally do not have as much leverage as a secured creditor would have. Often they are referred to as the trade creditors, and as a result, in larger cases, unsecured creditors, at the direction of the United States trustee, which is a different entity than the trustee for a particular bankruptcy case that we were discussing earlier, will send letters to the top 20 largest creditors in a particular case, inviting them to participate in what's called the creditors committee. Depending on the size of the case, the U.S. trustee will hold a meeting, and those invited creditors will come to the meeting if they have submitted a form, or they can submit the form at the meeting, indicating their willingness to participate in the committee. The trustee will review all of the volunteers for the committee and select a committee anywhere from 5 to 10 members, given the size of the case. The committee acts in a fiduciary capacity and acts on behalf as a representative of all unsecured creditors. So it is not wise to sign up for a creditors committee in order to advance your own claim, because you do have fiduciary obligations and it's a representative position. It's basically to act as a watchdog against potential abuses by the debtor and any secured creditors. And this committee is often just referred to as the Creditors Committee. The official committee of unsecured creditors, that's a bit of a mouthful, so Creditors Committee is usually what it's referred to. I referred a moment ago to the United States Trustee. Let me explain who that is briefly. The United States Trustee is a government watchdog office that oversees and regulates certain procedures in a bankruptcy case. The United States Trustee does not manage the debtor's affairs or business or otherwise act on the debtor's behalf. The United States Trustee is more appropriately viewed as an advisor to the bankruptcy court on procedural and other matters in all bankruptcy cases. The United States Trustee is also the entity, as I mentioned earlier, that selects the creditors who will sit on any committee. So let's discuss now sort of more Chapter 11. Chapter 11 is the reorganization chapter. Debtor retains property and continues to operate its business. A bankruptcy trustee can be appointed in a Chapter 11. It's referred to as a Chapter 11 trustee. That can be done on the motion of creditors or other parties in interest. This is usually done only if there is some misconduct by the debtors in possession or some fraud or some reason why the ordinary course of Chapter 11 with the DIP remaining in control of the assets needs to be reordered. The debtor is to formulate a plan of reorganization that has to be approved both by the court and all the creditors. Upon confirmation of this plan, creditors are paid pursuant to the terms of the plan, and the debtor is discharged from further liability. But again, let me explain the concept of discharge in Chapter 11 verses 7 and 13. 13 is the reorganization chapter for individuals, and I just want to highlight that corporations are not entitled to a discharge. This is a very common mistake in the lingo that is made by lay people very often. One of the mistakes that you see in bankruptcy court is that for an individual, when an individual files bankruptcy, you have 60 days from the first meeting of creditors, which I'll describe in a moment, in which to object to the discharge. And what that means is that the debt will follow that person through the bankruptcy. It will be something you can chase them on for, years to come, because the bankruptcy will not have washed it away. There is no corresponding discharge for a corporation, so there is no objection to discharge. The reason for this is that basically the company ceases to exist upon the filing of the petition. The debtor, as it was known prior to bankruptcy, does not come out the other side. The reorganized debtor is a sort of a function of law, is a different entity. So the debts, whatever they were, reside with that initial company, the initial entity that filed for bankruptcy protection. So for all intents and purposes, there is something that effectuates a discharge of the debt, in that you cannot chase that company once they have filed bankruptcy to collect your debt. But it is not described as a discharge. It is more of a function of law that the entities are different pre and post petition. So I want to make sure there's no confusion on that score. It is also a mistake to assume that because Chapter 11 is a reorganization chapter, that you can't liquidate in Chapter 11. There are Chapter 11 liquidating plans. So there can be a way for a debtor to remain in control, but the result is more of an orderly disposition of the assets, and it's part of the plan to sort of liquidate everything and sell it off either in one big piece or in a handful of pieces. Part of the incentive for doing something like this, as opposed to filing a Chapter 7, is that, again, in Chapter 11, the debtor remains in control of the assets. As most people can understand, the sale of an ongoing concern is usually of more value than something that is shut down and viewed more as a fire sale. You're not going to get the highest and best price, usually in a Chapter 7, which is more the fire sale type scenario. One of the very first things that will happen after, or in fact the very first thing that will happen once a petition for bankruptcy relief is filed, is that there's an automatic stay. And what this does is provide the debtor with immediate protection against harassment and collection efforts of creditors. Upon the filing of a petition, the automatic stay precludes commencement or continuation of any action against the debtor or debtor's property. Intentional violations of the stay may result in sanctions and fines. Bankruptcy courts do not take kindly to any monkeying around with a debtor in possession. Sanctions will be swift, they will be harsh. I encourage you not to take the automatic stay lightly. Creditors, however, and this is something that I absolutely encourage, even if your legal research and your analysis of the facts of your particular situation, you have all sorts of arguments that the automatic stay really isn't in place for your situation. You've got arguments as to how it perhaps isn't an asset of the estate, or that it's not really the debtor who's implicated. If you have a moment's reason for hesitation, your best course of action is always to file a motion for lifting of the automatic stay. There is an $150 filing fee that will be a sunk cost, and whatever your lawyer time is to get it filed. But it is so much better in this particular instance to ask for permission. There are lots of instances where I'm sure we as lawyers give the advice, just do it and ask for permission, worry about the consequences later. Not with the automatic stay. You are always better taking the prophylactic move to request the lifting of the automatic stay before you decide to do anything that could even remotely impact the debtor's assets. The other thing, another term, is adequate protection. Creditors may also receive relief from the stay upon a showing of lack of adequate protection. And what that means is that they're a secured creditor, and there's something with respect to the debtors keeping the interest in the property, the secured creditor not having access to the property, that can diminish its value, that if the secured creditor isn't allowed lifting of the stay to go get their property, to foreclose, to seize equipment, whatever it may be, that there will be a diminution in value and the creditor will be harmed. Depending on the particular case, there is the option for a debtor to provide adequate protection in the form of cash payments or grant a replacement lien on additional property of the estate. A trustee or debtor in possession may use, sell, or lease property of the estate in the ordinary course of business without court approval. So you do not, as a debtor in possession, have to go into court every single time you want to do anything. As long as it's part of your ordinary business and what you always did, you can continue doing it. You do need to go into the court for approval in extraordinary circumstances. Are you selling a division of the company? Are you selling a whole line of equipment, and that isn't your business to sell lines of equipment. Usually you use the lines of equipment. Those types of sales do need to be approved by the court, and that's in order to provide all the creditors notice and make sure the debtor's not engaging in any sweetheart deals of any kind. There will be a restriction on the use of cash collateral once you file. So if you have a secured facility with a bank and they have a security interest in all of your cash and accounts receivable and everything like that, you will not be able to use those funds, those operating funds, without permission from the secured creditor. So that is something to definitely consider pre-filing, whether there's going to be any cash for operations. Another thing that happens in bankruptcy is there are avoidance powers. So the trustee or debtor in possession has the power to unwind and recover certain preferential transfers or fraudulent transfers made by the debtor to creditors or insiders of the business. The most common avoidance power are preferences that I will discuss in a little bit. There are also issues that deal with leases and executory contracts. Executory contracts are contracts, in the simplest terms, that have not been fully performed. And one of the things the debtor will have to decide is whether to assume or reject those contracts. Another term that we use are proofs of claim. A creditor asserts a claim against a debtor by filing a proof of claim with the bankruptcy court. There's a standard form that can be found on all of the bankruptcy court websites, just on their informational pages all across the country, and requires a creditor to state under penalty of perjury the amount and basis for the asserted claim. In certain very large cases, the debtor will retain a claims agent, and there may be a specific form with specific instructions. Proofs of claim can be filed immediately. You may also wait until you receive the bar date notice, which is the notice of the last date upon which, by which claims may be filed. And oftentimes, if there is a special form, it will be attached to that bar date notice, and if there are certain instructions that you won't be filing the claim with the court, but rather you'll be filing it with the claims agent. The order of distribution. There are essentially 3 levels of distribution to creditors. Secured creditors are paid first and will either receive their collateral or proceeds from a sale of the collateral. Second, certain unsecured claims such as taxes, operating costs, and employee wages are paid. These claims are called unsecured priority claims. Last on the distribution list are the non-priority unsecured creditors. They share whatever property, if any, remains. Equity of a Chapter 11 debtor only participates in a distribution if creditors are all paid in full. So the general rule of thumb is that equity is wiped out in a Chapter 11. So now I'm going to move on to the basic information that you need to collect if you are an entity considering filing for Chapter 11. The first thing to start gathering are the outstanding executory contracts. So again, these are contracts where material performance obligations remain unperformed for both the debtor and the other party to the contract. Executory contracts do not include outstanding notes, liens, or other security agreements. Some of these contracts may not be at corporate headquarters or hard to find. Again, some may never have been written to begin with. You will need to schedule these executory contracts, and they may also end up becoming the subject of motions by the other parties to those contracts who would like you to compel your assumption or rejection of them. The next thing together are leases. So all unexpired leases for both real and personal property must be collected and duplicated. Such materials should also include copies of related assignments, subleases, reciprocal easement agreements, and similar documents. For equipment leases, you should consider whether it's a true lease or a financing lease. For instance, where a purchase option is de minimis, often those are called buck-out leases. There's a provision that says at the end of the term the equipment can be purchased for $1, so hence the buck-out phrase. For instance, where a purchase option is a buck-out and will be exercised as a foregone conclusion, it might be a financing lease rather than a true lease. And the leases will be used in the following ways. Schedules. Shortly after filing, schedules will be filed which need to list every lease, including the name and address of the other parties to the lease, and a description of the lease, the nature of the debtor's interest, and whether the lease involves non-residential real property. For non-residential real property leases, the bankruptcy requires a decision be made within 60 days of the filing as to whether to assume or reject the lease. This period can be extended for cause by the bankruptcy court after notice to landlords, and in larger cases, an extension motion is often granted. However, with the revisions in 2005, there is a limit on how many extensions you can receive. It is absolutely not a foregone conclusion. The 2005 revisions put the power squarely within the hands of the landlord. So at most, you should expect that you have 120 days to decide what you are doing with these leases. And there are, other issues with respect to the leases, as tax obligations and who's responsible for those payments and when they are due. One of the things to inquire with respect to the jurisdiction in which you are filing, if you are a company that has a lot of non-residential real estate leases, is there are some jurisdictions that say if your rent is due on the first of the month and you file on the second of the month, that entire month's rent is considered a pre-petition obligation, and therefore it wouldn't have to be paid until the plan. That would be something the landlord would have to just file a proof of claim for. There are other jurisdictions, though, that say the rent obligation is prorated. So even if rent is due on the first, if you file on the second, you would have to pay rent from the second through the 30th of the month. So that's something to consider when picking a jurisdiction in which to file. If these are residential leases that you plan to assume, however, that is of no consequence, because a requirement for assumption of a lease is that you cure all defaults. So if there are payment defaults, if there is rent that has not been paid in advance of the petition date, you will need to come current. So again, that concern as to filing date for the petition date really deals with leases that you want to reject, which is oftentimes a driving motivator for a debtor filing a Chapter 11, because it is a great tool to get out of leases, especially when you either have facilities you no longer need, you're a large retail restaurant establishment with leases for facilities that are closed, or you would like to keep the stores going, but you find yourself facing a lot of above market rents. And so you'll want to be able to renegotiate those or move to another location with a market rent. With respect to other leases, so we are putting aside the real estate now, with respect to other leases and these executory contracts, debtors usually have until the confirmation of the plan to decide what they're doing with the agreements. The other party to that contract, though, does have the ability to come into court and file a motion to compel a sooner assumption of the contract. The next thing you'll want to gather are insurance policies and related documents, and this includes workers' liability, workers' compensation, products liability, personal injury, property insurance, professional and executive committee liability insurance, performance bonds. A list of these insurance policies must be prepared, which contains the following information: name and address of the insurer, summary of the coverage, termination or expiration dates, premium payment schedule, deductibles, self-insured portions. All of this must be provided, again, in connection with the schedules. So you can see waiting to approach a bankruptcy lawyer 5 days before you're going to miss payroll is not exactly the best time to attempt to file for bankruptcy. There's a lot of work to do, a lot of schedules to be put together. So the longer planning one can do for this, the smoother filing a bankruptcy will be. With respect to insurance policies that may expire early in the bankruptcy case, there needs to be a renewal strategy identified because the debtor has to maintain certain basic insurance, such as property insurance, during the case. And there's also an issue with respect to policies that are subject to retrospective premium adjustments, and those will very often be the subject of litigation once a company's in bankruptcy. The next items you should be gathering are everything related to your employees, so compensation, benefits, summary of all existing employee plans, 401k plans, profit-sharing plans, medical and dental, and these all need to be summarized with respect to the schedule. Just so you understand that for employees, there is a sort of carve-out of $10,950 per employee. That's a priority expense, so that will come in front of general unsecured. The Bankruptcy Code is a policy of basically attempting to protect employees. They don't want the employee to have to bear the brunt of a bankruptcy filing. And so there will be an amount per employee for unpaid pre-petition wages and benefits in that amount. And so one of the ways for employees who would exceed that amount, you'll want to make sure that they are all currently paid by the time you file, because if there's any gaps, that will be the cap that you will be allowed to pay that employee for the pre-petition unpaid obligations. The next thing, obviously, you need is a list of all unsecured creditors that have done business with the debtor during the past year, including creditors that the debtor does not currently owe money. And so again, you need detailed information for all of these creditors and what the debt is for, address, all of that information. To the extent shareholders, directors, and officers of the debtor have claims against the debtor, including contingent claims for indemnity, they have to be listed in the list of all creditors of the debtor as well. They should not be omitted. The petition does require an alphabetical list of creditors with name and address, and it also, along with the petition, you need the 20 largest creditors. So this information needs to be organized in a handful of ways. Earlier in the discussion, I mentioned claims agents, and for some of the larger cases, people retain firms with specific skills in this area. The other thing that the companies do who are claims agents, they also handle preparation of the schedules. And so they will have very large databases, very detailed ways, proprietary ways of gathering this information, especially in large cases, and getting it all organized in the right sort of bankruptcy format. One of the other things that will need to be analyzed, but not necessarily in advance of filing, is you'll need to have a very good handle on all the payments that were made by the debtor in the 90 days leading up to bankruptcy. And that is because that is the preference period, and those are the payments that can be recaptured in the avoidance powers that I discussed earlier, that I will discuss in further detail in a moment. And the other issue with that is the 90-day window is extended to 1 year with respect to insiders. So you'll want to have, again, very good books and records as to where the money has gone, especially in the recent time frame leading up to the filing. You'll need a list of all the secured creditors and all the amounts owed. You will also need to have detailed information regarding priority unsecured creditors, so the unpaid wages, unpaid contributions to benefit plans, any unpaid taxes owed to any taxing authority. That would need to be scheduled. You'll need to get a handle on all pending litigation, because even if lawsuits haven't been filed, these are people who would have claims against the company, and insofar as you know, the pending litigation are the items that have been filed, and so pending litigation along with threatened litigation, you'll need both lists as comprehensive as possible. And the reason for this is, in order for a creditor's claim to stay with the old company and for them to basically be stuck with whatever liquidation value or whatever the plan provides creditors, the creditor must receive notice. So on the pending litigation, you will need to provide them notice so they understand, one, that the automatic stay is in place, and therefore the litigation that is ongoing can no longer proceed and has to halt wherever it is in its process as soon as the bankruptcy is filed. And then again, you will want to contact anybody with threatened litigation. Again, this is all after you filed, but you need to gather the information in advance. The threatened litigation, because you will want to notify them that they should not be filing a lawsuit against you, because the automatic stay is in place for the filing of any new lawsuits, as well as the halting of ongoing litigation. You'll need a list of all relevant taxing authorities, because all the government entities will need to receive notice of your bankruptcy. You will need a list of licensing authorities with whom the debtor has dealt with in the past 2 years. And the other issue with that to be on the alert for is that some licensing authorities, once you file bankruptcy, may attempt to require additional things from you in order to renew your license. And just to be aware, the Bankruptcy Code specifically prohibits governmental entities from discriminating against an entity solely because of their bankruptcy. So if you want to be aware of anything that's going on with your licenses, and if there's any difficulty renewing any license, so that you can bring it to the attention of the bankruptcy court. You will need a list of all bank accounts. In some cases, you can file a motion with the bankruptcy court to allow the operation of the same bank accounts, both pre and post petition, as long as you can demonstrate to the court that you sort of have a line drawn in the sand, and that any checks that were issued before the bankruptcy won't be able to clear, and that it will operate, because there needs to be a clear division between what was pre-petition and what was post-petition. And so a lot of times courts do require the opening of all brand new accounts. And so whatever funds are in the debtor's possession as of the petition date get moved to new accounts, and whatever checks are outstanding or anything that would go off the old accounts just goes unpaid, and those become pre-petition claims of the creditor. You will also need a list of investments and assets, so that you can make the initial disclosures on the bankruptcy petition as to what your liabilities are and what your assets are. And of course you need this information in order to figure out how it is you're planning to emerge from bankruptcy. Excuse me. Also, there are guidelines for what investments can be maintained post-petition, and the guidelines are pretty conservative, and this is to minimize any further loss of assets. So, and these guidelines can be obtained from the U.S. Trustee's office, and the U.S. Trustee has a website, and all of that information should be available there. You'll want to conduct lien searches. There may be creditors out there who have attached or put liens on your assets that you didn't know about. Hopefully you know who all of your secured creditors are, but you might not. So lien searches should be run, because also you're going to want to notify, as part of the filing process, any of the lien creditors that you find. You will need your employer tax identification number, and that has to be placed on the Chapter 11 petition. Any trade names used during the past 6 years also have to be listed as part of the petition. And then you will need to get the debtor's financial and stock records. You'll need the debtor's most recent balance sheet, income statement. It must be presented in summary form in the petition. And then you'll also need to list classes of stock and the number of shares in each class. And then you'll need to list people or individuals or entities that hold 20% of the debtor stock, and then also any subsidiaries of the debtor in which the debtor holds at least 20% or interest in the sub. The biggest thing is to make sure you've got all of your ducks in a row and gather all of your books and records from the previous 6 years, and that would include auditors' reports, inside and outside financial audits, any types of documents like that. One of the things you'll want to do in advance of filing for bankruptcy is to see if you can find any post-petition financing. This will alleviate the issue that I was discussing before about having your cash collateral freeze, that if you have some other avenue to financing. That is one of the things to just veer off very briefly into the why are there not as many bankruptcies as one would expect in 2009, 2010. the dry up of the credit markets has been exceptionally profound in the area of DIP financing, and so there really isn't a lot of bankruptcy financing available. And one of the things about bankruptcy is one can be too broke to file for bankruptcy. So without post-petition financing, I think there are many companies that have just had to close up shop because you need to be able to pay professionals, you need to be able to operate your business and buy inventory and the other things that you need to do. And if you have no access to cash during the bankruptcy, you will not be successful. One of the options to look at for post-petition financing is often the current lender will provide post-petition financing. I need to pause it really quick.
Sure.
Sorry. Okay.
And we are good to go.
Oftentimes your current lender will provide financing if there is perhaps some collateral that is not already pledged to someone. You can use that to incentivize them. Oftentimes they will just take a super priority lien in all of the assets upon which they currently have a lien, and oftentimes you can get a current lender to agree to become a post-petition lender in the event they are oversecured. But in this current marketplace, that isn't the case very often. You will need to prepare a budget, a detailed week-by-week budget of 14 to 21 days. And that's going to be necessary in order to do anything with cash collateral and to get any, if you did find any DIP financing, to get that approved with the court. You're not going to get a blanket permission to get financing. The judge and the other interested parties will want to know what the money's being used for and how it's being used. And the expenditures, you'll want to have some ability to demonstrate or argue that they're necessary and benefit the estate in some long-term way. And a longer budget will eventually be required, I'm sure, from the DIP financer, if not from the creditors committee and other interested parties. You'll want to identify critical trade suppliers. So insofar as there are trade creditors for without whom you cannot do your business, you will need to figure out what your payment status is with them and how you want to deal with them going forward. And if you want to make any address to the bankruptcy court to treat those particular unsecured trade creditors differently than what you consider non-critical trade creditors, some jurisdictions allow such a distinction and some don't. You also will need to identify which professionals need to be retained. And that is not just your bankruptcy attorneys, that is any attorneys that you have working for you on any type of matters. Perhaps there's some litigation that will need to get up and go running once again, once the initial shock of the bankruptcy petition has subsided, including cases where the debtor may be the plaintiff. You will need to deal with accountants. You will need to perhaps pay for your claims agent that I've referenced before and the entity that's assisting with the schedules. There may be investment bankers that need to be retained or other consultants with respect to selling all of the business or substantially all of the business. There may be a chief restructuring officer who's been brought in to try to turn the business around. There may be public relations professionals that need to be retained in order to do crisis message management and things of that sort. So here's some pre-filing documents and actions that you need to consider if you're going to perhaps be a debtor. You will want to have an executive committee sort of question and answer, a small group of officers or retained professionals who are going to be the last word. There's going to be lots of conflicting information coming around, and you want to identify, one or a handful of people who are going to be the people who can provide the answer to the question. People will be secure knowing that these are the 4 people we can ask, and we don't have to worry about all this noise over here coming from, people who really aren't charged with having the final decision-making authority. Insofar as you're using non-bankruptcy professionals and in-house people who, for example, a manager that the employees are very comfortable with, you'll want to prepare, have your lawyers prepare a brief sort of list of frequently asked questions and appropriate answers. You're going to want to provide letters to your management regarding what happens in a Chapter 11 and what their duties are and how anything will change. You will want to have your accounting people all set up, because they're going to need to be providing monthly operating reports, and insofar as your software systems aren't set up for that, you're going to have to get ready to provide that type of information. You are going to have to make sure there are procedures that once the bankruptcy is filed, no pre-petition debt is paid. You can't have any rogue accounts payable people who are picking and choosing some petitions to pay of people that they are close to. You'll also want to make sure you have very frank discussions with your salespeople and other people who are responsible for customer and vendor relationships to make sure that no promises are being made about payments. It's not that such promises would be enforceable. They wouldn't. It would be that will greatly damage your business, because I think one of the things that customers and vendors get most upset about frankly is not that they didn't get paid. It's that their expectations weren't managed appropriately, that they felt they were lied to, that they were surprised in any way. So you want to make sure that accurate information is getting out, and that none of your people are sort of doing a wink, wink, nudge, nudge with certain creditors who think that they'll, get sort of made whole on the end and things like that. That is a road also to getting a Chapter 11 trustee appointed and having the debtor no longer in charge of operating the business if things such as that come to light. There will need to be appropriate last-minute announcements to employees. Obviously, you don't want people knowing about the bankruptcy in advance if you can help it, because that is a way for your vendors to tighten up payments and various other things on you, and so it can end up creating a snowball effect on your payable side and on your receivable. If people hear that you aren't doing so well, they're not going to really be too worried about paying your invoices. So you'll need to time the announcement to employees properly. And again, this is where you point out to the employees who this executive committee is, who this small group of people is who can properly answer their questions, so that everyone's getting the same information. You'll also want to contact your key clients and suppliers. If you're trying to reorganize and get the business off the ground, the worst thing that you can do is clam up and be silent. People like information. People get nervous when they don't hear what's happening. Have your most charismatic people and salespeople contacting your suppliers and your clients, and reassuring them and explaining what the plan is insofar as you guys know. Paint in broad brushstrokes if you don't. Again, I'm not saying tell them things that aren't true, but insofar as you guys have a plan, a roadmap for how you're going to get out of this, share it with people. People understand that bad things happen to companies and people get in a bind, and the more you can get your story out there, the better. You'll need to have appropriate authorizing resolutions. That's something you can talk to your corporate counsel about. You'll want to think about your employment agreements and methods of retaining key employees. This has been, frankly, made much more difficult since the 2005 Bankruptcy Code revisions. It is very difficult to treat key managers better or bonus them out for sticking around. So if there are people that you're very worried about losing, have a very frank discussion with your bankruptcy counsel about what steps, if any, can be taken to try to keep them. If you get a chance and the case is big enough and your counsel is connected, which hopefully they are, they should contact the U.S. trustee and give them a heads up that it's coming, so that you can sort of hit the ground running and not run into any big roadblocks of the trustee sort of throwing up their arms saying, they don't really know anything about this, or they have particular objections that perhaps you could have worked out in advance with the U.S. trustee. Make sure you've got your press release ready. And then insofar as you are getting documents on a regular basis, inventory and goods on a regular basis from suppliers, be prepared for the reclamation process that may go on. Reclamation does still exist even in bankruptcy. It's from Article 9, and it's where someone in transit who's delivered goods to you and that are in transit, if there's a material breach or you're insolvent, can recapture the goods before they get to you. So be prepared for that. If anything's sort of on the road that you really need, make sure you get it before you file so that it can't get stopped in transit. Also, you could end up getting flooded with reclamation demands right after you file. And so make sure you've got some type of program to figure out how you're going to deal with this. And there's all sorts of various strategies one can do, and you should look and see what the elements of reclamation are. For example, one of the elements is that the material, once it gets to you, the purchaser, it's readily identifiable. So somebody could go in and say, that's my blue widgets. I know those are my blue widgets. I want them back. So if you are getting similar type stuff from lots of different groups, one way to defend against reclamation claims is if you mix it all together right away when you get it, as opposed to keeping it in the identified boxes, and then that will defeat a reclamation claim. I'm not saying that's a surefire way to get out of it, but it's better than keeping all the boxes lined up, readily identifiable, Joe's blue widgets, which you're going to have a hard time saying why he should be able to come pick that up. There's a list in the materials of all of the early bankruptcy pleadings that are sometimes referred to as the first day motions. I'm not going to go through those in detail here. There's a listing of several pages. One of the ones that I will address, though, is that oftentimes debtors will file something that is called a motion to provide adequate assurance to utilities. And what that is it's a motion that they will file, and they'll list all the utilities with which the debtor has relationships, and will say, we will give a deposit to the utility of 1 month's usage or 2 weeks' usage. And sometimes they'll propose that it's held in an escrow account. Sometimes they propose it'll be paid to the utility. And judge, enter this order that will prohibit the utilities from doing anything to, cut our power or turn off the gas or the phones, and say that this deposit is acceptable. Section 366, which is what governs this utility provision, was revised in 2005. This practice of filing a motion with respect to utilities is ongoing. People are doing it the same way as they did it in 2003, 2004. But there is some question as to whether that is what Section 366 now requires. A plain reading of 366 could be interpreted that the debtor has to contact the utility, find out what the utility demands as adequate assurance, pay that to the utility, and if the debtor feels that that was too high or was exorbitant, that it is then that the debtor goes in to ask the court to say, look, the utility requested X plus 5. I really think that the deposit should be X plus 2. Please modify it accordingly. So there is some question as to whether utilities should continue to remain a first day motion. Just so that everyone is aware, though, the utilities are prohibited from taking any action for the first 20 days after filing the bankruptcy. So even if there are great arrears to the utilities, they cannot actually cut you, even absent an adequate assurance payment, for 20 days. So there's also a list of all the schedules that need to be prepared that I discussed in the beginning. So real property, personal property, creditors holding secured claims, creditors holding unsecured priority claims, creditors holding unsecured non-priority claims, which again is the trade, general unsecured, executory contracts and unexpired leases, and then any co-debtors. And of course, a list of all of these schedules is found in the Bankruptcy Code. Oftentimes, if a debtor has been prepared well enough in advance of the filing of the bankruptcy, so again, you're not preparing to file bankruptcy 5 days before you're going to miss payroll, but really you've had the professionals in, the accountants, the bankruptcy lawyers, the claims agents, schedule preparers, everybody getting this all together. For a lot of the large cases, bankruptcy schedules are submitted with the petition. You do have 15 days to submit the schedule, so if there is a crisis and you're going to miss payroll and you need to file, the bankruptcy petition is just one piece of paper. And then the schedules and the various summaries can be attached later. You may also request a extension of time to file these, but usually it's not going to be indefinite, because as you can imagine, without this detailed information being provided, no one really knows what's happening with the case and what the status of the bankruptcy is and what the status of the company is. So these schedules are something that really need to be worked on around the clock and should be filed as close to the petition date as possible. The next thing the debtor needs to do is prepare for the initial meeting of creditors, and this will be held by the U.S. trustee. A notice of this meeting will be sent out by the U.S. trustee. It's called a 341 meeting in our lingo, and the debtor will appear accompanied by counsel, and the U.S. trustee will ask all sorts of questions about the schedules, and that meeting is under oath. It will be recorded, and any creditor may show up and participate in the meeting, even though in general practice it usually is only the U.S. trustee who asks any questions. It is after you file that there may be a formation of a creditors committee. Again, that is nothing that the debtor is really involved with. Usually the debtor appears at the formation meeting, but again, that isn't necessarily required. Another thing that the debtor should prepare for is what defenses, if any, they have to modifications, motions to modify the automatic stay. So as I discussed earlier, a creditor may come in and say, I need the stay modified, I need to get at my collateral, my real estate, my equipment, whatever it is. And be prepared for what your response to that is going to be, what defenses you may have to their getting relief from the stay. This is particularly an issue where you are filing bankruptcy solely for the purpose, or one of your main purposes is to thwart that particular creditor. So you are in litigation with a creditor who's attempting to foreclose on your assets. It's the eve of them getting their hands on your property, and you file for bankruptcy. You can pretty much expect that secured creditor will be in getting a motion, or will be having their motion heard to lift the automatic stay to continue going after you, and will view your bankruptcy as merely a blip or a momentary delay, unless you've got some good reason for why the automatic stay should hold them off for a longer period of time. Again, you need to get prepared for a monthly operating report, and the final thing is that there will need to be quarterly fees paid to the U.S. trustee's office, and so you'll need to be prepared to at least have that cash, because as you can imagine, if you don't pay the U.S. trustee's office, that's a really good way to get your case converted or dismissed. So you'll want to make sure that you are in compliance with that. Now I'm going to discuss some things that may have been covered a little bit earlier in the talk, but the next portion of the materials talk about the commencement of a bankruptcy case. So all the things I was just talking about were really the things you're going to want to be gathering in the 1 week, 2 week, I've heard sometimes 6 months, in preparation for filing your case. So now we're going to talk about the actual hands-on filing of the case. So we've already gone over who may file. There's voluntary and involuntary. And involuntary may be filed by 3 or more creditors holding at least $13,475 in unsecured claims, which are not in a bona fide dispute. So if you are a creditor who's got an account stated claim or something of those lines, you'll and you're trying to find 2 more creditors to throw someone into bankruptcy, you'll really want to make sure that these people have good, legitimate claims, and your best bet is to find trade creditors who just sort of have invoices that are unpaid, as opposed to somebody with some large contingent claim that may or may not fit the bill. Oftentimes what happens once an involuntary is filed is the debtor will consent to the case and basically take it away from the creditors who filed it, and it will become a voluntary case, and we'll proceed from there with the debtor in possession and things like that. So if the involuntary was filed because of shenanigans and wrongdoing and malfeasance happening at the debtor, those same creditors who filed the involuntary proceeding will want to be prepared to move for a Chapter 11 trustee or to convert the case to a Chapter 7. The one word of caution that I always provide to any clients who come to me seeking an involuntary is you can't get blood from a stone. And I think a lot of times lay people are under the impression that bankruptcy somehow makes things better. And bankruptcy does not create money where there is no money. And bankruptcy is also very expensive as far as professionals are concerned. And there's no guarantee that a creditor who seeks to file an involuntary petition will get their fees paid out of the estate. There are certain showings that need to be made if that could ever happen. And so I always like to caution anyone who thinks an involuntary is any type of magic solution to problems with someone who owes you a lot of money. The other thing to think about when you are considering filing an involuntary is that if the debtor can get the case dismissed, it is almost certain that you will be sanctioned for filing the involuntary that doesn't stick. So you'll really want to be sure, because you do have exposure, and not only sanctions, but also you will be responsible for the debtor's legal fees in getting out of the case. So definitely take that under very serious consideration before you do anything along those lines. So I want to go over now. So you filed the bankruptcy, and property of the estate. I want to highlight for you what that is. It's not just excuse me, the hard assets of the estate. It's also intangible assets. So insofar as the debtor has claims against insiders or other companies or things like that, once you become a debtor, you no longer get to pick and choose what you think are sort of worthwhile and maybe not pursue claims against friends or colleagues and things like that. Once you become a debtor in possession, you are a fiduciary to all unsecured creditors, plus you have everybody peeking into everything. And so there may be some claim against your brother-in-law's company that you thought was sort of marginal, this, that, and the other thing. The chance that that claim will take off once you file bankruptcy is pretty good. And so you'll have to remember these kinds of things, that once you get into bankruptcy, while the debtor in possession does remain in control, the property of the estate is really the property of the creditors, and they will ensure that every single avenue is explored in order to maximize and marshal the property of the estate. So again, we discussed a little bit earlier the ranking of claims, and I want to describe one particular item called the absolute priority rule. And what that means is that creditors are ranked according to their relative priority and their respective rights to receive payment. An absolute priority rule means, it fell down.
Sure.
There we go. I want to go over the absolute priority rule. And what this is, and this goes earlier to how I was discussing the ranking of claims, it provides that creditors are to be ranked according to the relative priority of their respective rights and receive payment, and that no lower or inferior class may be paid until the preceding class has been paid in full, unless the affected party agrees otherwise. So what that means is that you can't pay unsecured priority unless the secureds have been paid in full. And the only way you can pay unsecured priority anything is, if you can't pay secureds in full, is if the secureds agree to that treatment. And everyone in the same class has to be treated the same way. That's a provision of confirming a plan. So that is basically the concept. And basically how that comes about is you don't want equity to get anything if unsecured creditors are being paid 10 cents on the dollar. So every inferior class is dependent on their treatment as to what happens to the class above it, unless there's some agreement to the contrary. The last thing I'm going to discuss are preferences. And the first thing I want to go over is what a preference is. And a preference is a cause of action that arises only under the Bankruptcy Code. And the basic concept is that it's a payment or other transfer that causes one creditor to be better off than similarly situated creditors. So one distinction that I want to stress is that a preference is not that you got paid faster than you ordinarily did, or slower payments can't be preferential. It's nothing to do with that. It is a bright line rule that looking back 90 days, you received, the key element of the transfer is that it's an interest of the debtor in property to or for the benefit of a creditor on account of an antecedent debt owed by the debtor before they paid you, made while the debtor was insolvent, and that is a rebuttable presumption, but you can imagine how for a bankrupt entity that will be difficult to disprove, made within 90 days of the petition date for non-insiders. The look back is 1 year for insiders, and that it enables the creditor to receive more than it would have received in a Chapter 7 liquidation. Now, there are some affirmative defenses to preferences, and I want to set forth and walk you through what some of those are. One of the things that you can do as a creditor is engage in some pre-bankruptcy preference protection planning, I like to call it. And when a customer, and for this, you need to be in real good contact with your accounts receivable people and understand what's going on and know who the slow pays are and things like that. And so when a customer is not paying current and seems to be having financial difficulties, you're going to want to think about how you can deal with incoming payments and their application to outstanding obligations in order to minimize your preference exposure. So one of the things that you can do is cut off all credit to that customer. So you require that all future orders are paid in a cash advance or cash on delivery basis, and that is the only thing. People ask me all the time, how do I insure against preference exposure? There is only one way, 100% way, and that is cash in advance or cash on delivery. Because one of the elements of a preference, as I just explained, is that it's payment on an antecedent debt. So if you are doing a current exchange, then there is no preference. But the issue, obviously, is that most people, in order to have customers, need to extend some sort of credit. So if you do continue to skip on credit, you may be able to use some other defenses. So an ordinary course of business defense. So ordinary course of business is that they are paying you the same way they always paid you. So yes, you received a payment on an old invoice in the 90 days leading up to their bankruptcy, but it was paid, the invoice was 60 days old, and if you look back at the 2-year history of your dealing with this company, they pay you 60 days out. Every time you send them an invoice, 60 days later, you get a payment. Those payments, as long as they're not different, are defensible as in the ordinary course. And a lot of times where clients get confused is they'll say, well, look, they paid me 90 days late, not 60 days late. Not 60 days after I sent the invoice. So how can it be a preference? They were slower. And it has nothing to do with that. Ordinary course has to do with it always being the same. And so one of the things you can do when you run into a client or a customer that is having difficulty is you should run a payment history for them and look at a 2-year history, see what their average time is to pay, and start applying your invoices if you can. This will only work if they're not designating which invoice to be paid, on their check or some other notation. If you can, try to apply it to invoices that most closely match your historical payment structure with these people. If you can. If you've got a lot of invoices open and you can pick and choose which one, try to pick the one that most closely matches the history you've had with them, because then you have the best argument for it being defensible. The other thing you need to do when you get checks from customers like this is you need to cash the check immediately. And that is because some courts hold that transfer occurs when you, not when you receive the check, but when the check is cashed. So don't make sure that checks are getting cashed immediately. The other thing to be aware of is, let's say you're running into difficulty with a customer, and so you decide to change terms. and you decide to go from a check to a wire. Well, there are some cases that hold that the changing of the payment method is now outside the ordinary course. So what you've just done, because you took it from a check to a wire, and you, even though it was the same time frame for payment, you've made it so that it's not ordinary course. Because the ordinary course was for them to pay you a check, not by wire. The other thing that people do, and this is counterintuitive, is they will change payment terms and say, you know what, I used to say, net 60, now you have to pay me in net 15. Well, they think, well, this is great. They're staying on top of this customer. They're going to be getting their payments in 15 days instead of 60 days. But again, what you have just done is you've made all of these payments now outside the ordinary course and subject to preference exposure. Even if you have a written agreement, that does not make it ordinary course. Ordinary course is not what your invoices say. It's nothing like that, which frankly for a lot of people is good, because a lot of people don't conduct their business relationships according to the terms of their written agreements. And so what the court's really looking at is how things actually happen in practice. And so don't be changing terms with someone you think is in financial difficulty. The last thing I want to say on this is that I get a lot of calls from clients who say, I'm really concerned about this payment. This customer called me. They want to make a payment, but I'm afraid they're in bankruptcy and it's going to be a preference. If you take nothing else away from this discussion today, take the following away. Always, always, always take the money. Take the money every single time. Preference exposure is never a reason not to accept payment. And the reason for this is that even if it's a preference, it was still payment of a valid debt. It was payment of an antecedent debt. It's not that preferences are some manufactured thing. It was an invoice. It was old. They paid it. It's always possible, and the reason you should always take the money is that it's always possible that this person who paid you isn't going to file bankruptcy for 100 days or 95 days. And what do you know? There is no preference. It's only, so you take the money and then you just wait. You wait until the 91st day and then you're free and clear. The other issue is that even if they file for bankruptcy, pursuit of preferences is not always guaranteed. They may not ever file any preference actions, so you were worrying for nothing. Second, you can end up hanging on to the money for up to 2 years before they file a preference action against you, and the chance that you're going to settle it out for something less than returning all of the money is very large. So don't ever reject a payment because of some concern about future preference exposure. You're always better off with somebody trying to get money out of you than you're trying to get money out of them. And with that, I am going to wrap up. Again, in the materials, they're very comprehensive. Even though I did touch on everything that is in them with respect to, I hope I gave some good information heavily from the debtor side, but also from the creditor side, and things for you to think of while you are faced with a debtor and you're a customer and you're faced with becoming a creditor in a bankruptcy, or you are a company that is in financial difficulty and you need to consider filing, and the various things to take into account. And I understand I'm addressing attorneys with this presentation, but I think that these are a good set of baseline issues for you to be able to advise your clients on. And of course, if things are complicated, seek bankruptcy advice.